1966 ခုနှစ်မြန်မာနိုင်ငံတရားစီရင်ထုံးစာမျက်နှာနံပါတ်239 Mathan and 1 applicant versus Matthews Joseph respondent ဤစီရင်ထုံး audio book ကိုအထက်တန်းရှေ့နေဦးအောင်ခိုင်ဦးအထက်တန်းရှေ့နေဒေါ်ပြည့်ပြည့်ဖြိုးနှင့်တရားလွှတ်တော်ရှေ့နေဦးထိန်လင်းဦးတို့မိသားစုကစီစဉ်ဆောင်ရွက်ပြီးဒေါ်ယူပါစောမင်းမှဖတ်ကြားခြင်းဖြစ်ပါသည် Civil Revision before ဦးသက်ဖေ Judge Mathan and 1 applicant versus Matthews Joseph respondent Code of Civil Procedure Order 26 Rule 5 issued of commissions for examination of witness residing abroad whether evidence relevant and essential for the proper decision of the suit whether application is bona fide held under Rule 5 Order 26 of the Code of Civil Procedure the issue of commission for examination of witnesses residing abroad can only be sanctioned if the evidence of the witnesses is relevant and essential for the proper decision of the suit. A party should not easily be deprived of the evidence which is necessary and essential to his case unless his application is modified. The futile attempts made by the petitioners to have their evidence taken DBNS before the departure of the witnesses to India and East Pakistan would go to show that their application for the issue of commission was bona fide and not actuated by any motive to delay the disposal of the suit. PAM Abdul Khadar and 10 others versus SM Mohideen Fan by proprietor SM Nagar Mira and 6 others 1955 BLR 123 AC MJ Shed Company versus Ramiza B and another AIR 1938 Madras 647 Izzat Minasat Mia versus Sabha Rao and others 1952 1953 volume 57 CWN 605 Massa the Asiatic Corporation versus Massa Mercantile Bank of India Limited 1957 BLR 288 HC refer to all for the applicants Johnson for the respondent Uttapi Judge in civil regular suit numbered 966 of 1963 of the Rangoon City Civil Code petitioners sue the respondent for recovery of debt 3,908 US rands mean profits and damages. The petitioner's case, in short, is that the respondent had been in occupation of 3 out of 4 rooms in the 2-storied building known as number 31, 137 Street, Rangoon, since the end of December 1961 as their tenant and that the respondent had failed to vacate from the ground floor room, although the tenancy had been terminated with effect from the end of December 1962 and that they had incurred the loss of jet 1,558 in payment of laborers' wages as a result of the respondent refusal to allow the workmen access to the rooms, which at the time of the respondent's occupation require minor work to be completed. The respondent contested petitioner's suit on various grounds, amongst which it was contended that he was in occupation of one ground floor room only and that he had never denied access to the petitioner's workmen at any time. On these pleadings, the trial court framed 6 issues, 3 of which read: 1. Are the plaintiff owners landlords of the suit building, and was the defendant formerly occupying 3 rooms in the suit building, as alleged in paragraph 10 of the plaint? 2. Has the defendant occupied the 2 rooms on the upper floor? If so, from which day and is the defendant liable to pay rent for the 2 rooms for the period of his occupation? 3. Did the plaintiff suffer loss on the grounds mentioned in paragraph 6 of the plaint and paragraph 8(3) of the plaint, and can the plaintiff ask for damages? At the hearing, the petitioner cited amongst other witnesses 1. Mr. A.R. Goose, who had once resided in one of the ground floor rooms of the house in question, and 1. Abdul Monaf, one of the workmen, who was alleged to have been denied free access to the rooms by the respondent. These witnesses could not, however, be examined for various reasons, with the result that A.R. Goose left for India on 25 July 1964 and Abdul Monaf departed for East Pakistan on 16 August 1964. The attempts of the petitioner to have their DBNS examination taken before their departure did not meet with success owing to the shortness of notice given about the date of their departure and also to the illness of the learned advocate for the respondent. The petitioners thereafter applied for issue of commission for examination of the said witnesses under Rule 5, Order 26 of the Code of Civil Procedure. After hearing objections raised by the respondent, the learned second judge, who had sessions of the case, rejected the petitioner's application on the ground that there had been inordinate delay in applying for the issue of commission. It is true that the petitioners applied for the issue of commission only on 27 May 1965, although the witnesses had left Burma on 25 July 1964 and 16 August 1964, but they had explained that the delay was due to the fact that permanent addresses of the witnesses could not easily be obtained. No one can deny that there had been an exodus of Indian nationals from Burma in recent months, and these refugees would have had time in their search for permanent home, and the delay in applying for the issue of commission cannot, under the circumstances, be said to be unreasonable and without cause. It has been said on behalf of the respondent that no revision lies against an interlocutory order of a subordinate court relating to the issue of commission. A complete answer to this argument is to be found in the decision in P.A.M. Abdul Qadir and 10 others versus S.M.M. Mohideen, firm by proprietor S.M. Nagor, Mira, and 6 others, 1, where it was held that the revision against an order refusing to issue commission for examination of a witness residing abroad was competent under Section 25 Rangoon City Civil Code Act. The issue of commission for examination of witnesses residing outside Burma will naturally occasion the delay in the disposal of the suit, which cannot be allowed to happen without adequate reason, especially when the courts are at this juncture trying their level best to reduce their respective fines under Rule 5, Order 26 of the Code of Civil Procedure. The issue of commission for examination of witnesses residing abroad can only be sanctioned if the evidence of those witnesses is relevant and essential for the proper decision of the suit. The wisdom of this rule is based on the principle that the refusal to allow a party to adduce evidence which is relevant and essential to his case would be tantamount to the denial of justice. In short, a party will be entitled to the issue of commission if he can establish that the evidence proposed to be taken is essential and necessary. It has been held in M.J. Shet and Company versus Ramiza B. and another 2, and in Izzat Minasat Mia versus C. Sepa Rao and others 3, that where a party has clearly established that the evidence of a witness is necessary, but he is not within his control or resident within the jurisdiction of the court, he is entitled as of right to a commission and that the court has no further discretion in the matter. Although I'm not prepared to the extent of laying down that a party is entitled as of right for the issue of commission when the requirements of Rule 5, Order 26 are fulfilled. I'm of opinion that a party should not easily be deprived of the evidence which is necessary and essential to his case unless his application is malified. In this connection, it has been ruled in Master the Asiatic Corporation versus Master Mercantile Bank of India Limited 4 that in the method of issue of commission to examine certain witnesses in a distant country, especially where his examination would cause delay, the court must be fully convinced that the evidence of such a witness is really relevant and necessary for the proper decision of the case. In the instant case, the learned advocate for the petitioners had stressed that it was essential and necessary to obtain the testimony of A.R. Ghosh and Abdul Monaf, on which the success of his suit really hinged. He contended that A.R. Ghosh, who had occupied one of the rooms of the house in question, would be able to testify whether the respondent was in occupation of 3 rooms as alleged by the petitioners or only 1 room as contended by the respondent, and the evidence of Abdul Monaf was also essential in deciding the question of damages claimed by the petitioners, inasmuch as he was one of the workmen to whom free access to the room was denied by the respondent. These allegations of the petitioners had not been traversed by the respondent, and it must therefore be taken as substantially correct. Besides, it must not be forgotten that the petitioners had made genuine, though full-time, attempts to have their evidence taken DBNS before their departure to India and East Pakistan, which would go to show that their application for the issue of commission was bona fide and not actuated by any motive to delay the disposal of the suit. Under these circumstances, I am of opinion that the lower court erred in rejecting the petitioner's request for issue of commission, which is hereby set aside, and I direct that the petitioners shall be permitted to issue commission for examination of A.R. Ghosh and Abdul Monaf. I would also like to suggest to the learned trial judge that pending the return of the commission papers, the hearing of the suit should proceed by examination of other witnesses so as to prevent undue delay in the disposal of the suit. In the circumstances of the case, the parties shall bear their own course so far as this application is concerned,